it was held that the plaintiff is entitled to a verdict $150 with costs. The defendant's actions were against Army protocol and refuted every principle of justice. No one is subject to military jurisdiction unless an officer, soldier, or sepoy, nor is any offense cognizable by the military tribunal or under its jurisdiction, but some act which is a breach of military service or a neglect of military discipline, and no one may be entitled to military punishment except as a consequence of a military trial and the sentence of a court martial. Although the Charter did not expressly introduce English law, the judiciary interpreted its provisions as introducing English law as it stood in England on 25 March into Penang as their territorial law. Even with that, the enforcement of various native laws or customs was not abolished but rather to diminish the importance of this law. Moreover, the Charter introduced existing law of England with the exception of a few cases where it was changed by express provision, and it made any previously existing law null and void. Regarding the case, the Charter of Justice was applied retrospectively to civil injuries in order for them to be redressed in accordance with English law. The Charter's aim was to preserve the locals from oppressions and inequality. As a result, its application must be changed to be taken to be Penang law. Stanley R., the British judge, stated that this was done before the Charter of Justice was promulgated here and before this court was established, which is true, but the Charter extends in terms of civil injuries that have been sustained, as well as to crime committed before the Charter. He also said that the Charter's objective is to protect the natives from oppression and injustice. In the first 20 years of British occupation, the administration detected according to their conscience, since there is no official body of law, the complaints and pleas for a better way of administering justice resulted in the introduction of the first Charter of Justice in Penang. In terms of criminal law, the Charter ordered the court to obey the law established by the Charter in order to enforce criminal justice where the parties were bound by English law. Meanwhile, in civil cases, there were at least two conditions in the Charter, which said that the court must give and pass judgment and sentencing in accordance with justice and right. Second, the Charter declared that when a religious jurisdiction was consulted on the court, it was to be practiced where religions, customs, and manners permitted it. It gave effect to many cases that existed in the Straits Settlements by introducing the Charter of Justice. For example, if English law has the authority to override court decisions made under local customary law. The second is how far the general rules of English law apply in the Straits Settlement. Due to the changes, the local people are said to be protected and discrimination and inequality, but it has been consistently stated as doctrine of our law that English law is not applicable to races with their own religions and social system, resulting in intolerable injustice and oppression. Nonetheless, the British did not practice as they stated in the Charter when they override the local customary law, authority of English law, as opposed to the only so far as the religions, manners, and customs of the inhabitants admits, where English law was not applicable until the customs of the local inhabitants disallowed. The British thought that their changes to the charter in this particular matter were better for the people, but the voices of local customs were overlooked. The introducing of the Charter of Justice with its adjustment had the effect of preventing bias and injustice and redressing any civil injury caused by English law, regardless of the time of its declaration.